Okay, evening everyone. I see people are joining us slowly but surely. It is 5:30 on my watch, so let's start. Just to give you a quick feedback on your first portfolio, I have about 10 papers left to grade. I hope to finish them tonight, and then I'll be releasing the scores. All of you did very well. So I really have no complaints. Some of you I saw ran out of time and you didn't get to all the questions, but then you did answer some of the other questions. So thank you for your efforts. So yeah, hopefully by tonight I will release the scores. Thank you for that. Okay, so like we said the last time, I hope the sound, I know the last time you complained about the sound. Is the sound a bit better now? Can you hear me now better? I know last time the sound was a bit bad. Can I just get an indication from somebody? Can you all hear me properly? I see Ms. Liebenberg is... okay, good. Thank you very much. Okay, so hello. I'll say hello to Kleinmond for you. Okay. Thank you, Teresa. Yeah, so as I think just for connectivity, I will switch off my camera while we're busy with the slideshow, and then as we go through the slideshow, I will, when we do questions and answers, I'll switch on my camera again. I think it just connectivity makes the connectivity a bit better. Like we said the last time with the last webinar, that we'll look at some various aspects today. From your side, there was a request that we look at child participation. So a bit of the webinar tonight will center around child participation and the how of child participation and the when and what things we must look at. Then we will look at the last of the rules that the last time we didn't look into details. We will have a look at that. And then the last bit is we will look at some of the proposed amendments to the Act. I see there's a lot of the proposed amendments that I am not looking at because I see they are struggling to get the amendment through Parliament, and I don't want us to focus too much on some of the amendments that might still, that's still under debate. But I just highlighted a few of them that I want you to take note of that will have an effect on your practices as and when it is implemented. So let me switch off my camera and let me go to the slideshow. Okay, so there we go. Okay. So as I said, we will look at Rule 31 of the proposed rules. That is the rule the last time we didn't look at in detail. That speaks to the time periods of the investigation. You will remember, I think it was Ms. Bamji from Tanin raised the concern about it seems that children's court matters go on and on and on, and there's no time limits, and when should this happen and by when it should happen. So I thought let's look at the proposed rule and have a bit of a discussion about it. And then, as I said, child participation, and then some of the proposals to the Act. I just want to say with regards to Rule 31, and we'll go through it, but I really want us to, once we had a look at the rule, I'm going to stop, and I really want us to have a discussion about it, because I think, in my opinion, I want to hear what you guys say, is that I think the rule, it's, for me, it's not straightforward. It's one of those things that if you read it, you wonder, what are they referring to? Are they referring to the start and then 90 days, or the 30 days from 90 days? And I really want us to discuss it, and I want to hear what you guys think about it. So the proposed Rule 31 will deal with the investigations to decide whether a child is in need of care and protection. So these are the rules or the time limits for those investigations. And it's important to remember that these time periods that I mention here will follow after a temporary safe care order has been confirmed. So a child has been removed or is under investigation, so with the Form 36, and then these proposed time periods will kick in. So the first period that they mentioned here is the matter must be brought before court within 90 calendar days after the removal of the child to temporary safe care by the designated social worker, and then they refer to section 1552 of the Children's Act. And if we just remind ourselves what 1552 says, it is before the child, and I'll just quickly read it to you, to say before the child is brought before the children's court, a designated social worker must investigate the matter and within 90 days compile a report in the prescribed manner on whether the child is in need of care and protection. So a matter must be brought before court within 90 calendar days after the removal of the child to temporary safe care. Then the rule goes further to say the matter must be adjourned for periods not exceeding 30 days at the time prior to the expiry of the 90-day period referred to in the above rule. Again, so as I say, we need to discuss this to see how you guys would interpret this. Then the next is that the purpose of these 30 days adjournment will be to consider whether the continuous detention of the child in a place of safety is still necessary and in the best interest of the child, and also to monitor the investigation and give such additional orders as considered to be in the best interest of the child, or amend or vary the detention order. So I think this is similar what is anyway happening in practice, because during an investigation, you will go to court and the court will make further, or the court will ask a progress report from the social worker, or the social worker will come to court and say, well, this and this is needed, and then the court will make further orders, or a lot of times maybe the place of safety need to be varied, because where the child is maybe not in the best interest of the child at that stage. So this is the purpose then of the 30-day postponements. And then so the rule goes further to say matters be adjourned for periods of not exceeding 30 days at the time after the expiry of the 90-day period, where the social worker has not submitted the report, provided that the court may request the social worker to submit oral or written reasons to explain why the investigation has not been completed. And further to say be adjourned for periods of not exceeding 14 days at the time after the submission of the report of the designated social worker and the allocation of a date for the hearing. So for me, I think the clearest time period here is to say that once the report has been filed, and that report then contains a recommendation, then the matter can be postponed for periods not exceeding 14 days for an allocation of a date. So for me, that it makes sense to say that you postpone it for 14 days and then a trial date is set, and then the matter is postponed for trial. These time periods will also apply for a child that was not removed but is subject to investigation. You will recall, if you go back to the Children's Act, there is situations where a social worker would not necessarily remove the child, but the social worker will still recommend that there is an investigation into if the child is in need of care and protection, even though the child is not removed. So these time periods will also be applicable to those time periods. So if we, and that's why I said I think we need to have a bit of a sort of putting our heads together and discussing this a bit. So I want your input. How do you see these rules? If you want, I can go back to the first one. Let me see, go to the first one where we say, what do you guys think about this? Sorry, I just need to go back to the Teams. Okay, that's fine, Zenani. It's okay. Anyone wants to comment on this? What is your impression? I don't know. I don't know if Miss Bumji is. Let me see if she's here. I know she had a difficulty with this. I don't know if any of you have specific comments on what do you think, if this is workable. I just foresee that, for example, I know I was in the Randburg Children's Court about, I think, 2 weeks ago, and we postponed the matter, and we postponed it to March 2022. And you will agree with me that in no way is 90 days. But that is not an investigation. That specific matter is not an investigation matter in terms of a child in need of care. That is purely a residential contact and care dispute. So if I read the rules, then these rules, Rule 31 at least, is applicable only to children in need of care and protection. So as I say, my reading of it is that there's a 90-day period for the social worker to do a report, but within that 90 days, it would seem to me there should be a 30-day period which the matter should be in a court for like a monitoring of the order. And I always, as I said, I don't know in terms of a practical, in terms of court roles and court processes. I see, Teresa, you say I work mainly at Wynberg Children's Court. They are quite flexible with rules, and where possible, the magistrate helps with unusual situations. So she says, yeah, you're quite lucky. It works well. Okay. I know was also some of the magistrates would place a matter on the roll for these 30 days, which they then administratively review the order. In terms of, I'm just thinking that maybe this is a bit more of a legal argument to say, well, if you are acting for somebody, let me go back to, if I remember that matter of Tanin matter, where she had some real issues with the investigation and how the process is working, that 30 days postponement would be helpful, because then you don't have to wait the 90 days to come back to the court and say to the court, you know, social worker is dragging a feet, this is not happening, we're writing emails, this is not doing, so I think that 30 days postponements will be helpful in situations where you're not getting joy. But I think, as Teresa is saying, maybe in Wynberg maybe you can go to the magistrate, anticipate the date. There's a bit of, like you say, a bit of a more flexibility, which is a good thing. So if I look at the rules, it is maybe, in my opinion, maybe making the process a bit more transparent and giving all the parties an opportunity to be part of this investigation and raise objections and say, well, the continuous placement of the child with family member A is not working out, or family member A is biased towards a parent or a situation. So I think the rule has the sort of the idea behind the rule is good. I don't know to what extent we will be able to successfully enforce all these time periods in the courts. I don't know if somebody else wants to think or share what they think about the proposed amendment, or not amendment, sorry, the proposed rule. Okay, good. Okay, then we will move on to the next part, which we will deal with child participation. As very specifically, last time you asked that we specifically look at that. So I will go to that part of the slideshow. If you just give me an opportunity. There you go. Okay, so let me just get there. So child participation is, I want to look at it in terms of three steps, and let me, of child participation is through three questions to say why legal representation for children, and when should a legal representative be appointed, and what steps should the legal representative take. So why I talk about legal representation for children and then child participation, as the Children's Act stand now, and also if you read the Constitution, it specifically says that a child is entitled to a legal representative at state expense, where the substantial injustice will otherwise occur. So child participation currently as it stands is linked to legal representation. So a child will participate through a legal representative. That's why I'm sort of looking at child participation from the around the aspect of legal representation for children. So if we then say right to legal representation, we mentioned already, which I mentioned already, is the Constitution, Section 28(1)(h), which says that the child is entitled to legal representation at state expense if a substantial injustice will otherwise occur. And I think some of you already, I see in your assignments, in your first portfolios, you just referred to the judgment of Legal Aid versus R, which the court says that Legal Aid South Africa is then ideally in the position to provide that legal representation at state expense. But there's also nothing anywhere to say that somebody in private practice cannot act for a child pro bono. It's just the concept of legal representation if a substantial injustice will otherwise occur. And then also you find it in the UN Convention and also in the African Charter, this idea of child participation, of a child that must be heard, and the wishes of a child that must be taken into consideration. And then Section 10 of the Children's Act, that says specifically that a child taken into consideration, the age, the maturity, the stage of development, can participate in appropriate manner. Now, I think that's again a big part of where the big issues sometimes come in, because it says is to be able to participate in any matter concerning that child, and in an appropriate way, and the views expressed by the child must be given due consideration. So that participation, that's where a lot of the debate comes in, because if you look at some of the other jurisdictions, they would talk about direct and indirect representation. So if I take that back to our South African context, it is that looks at curators and then versus legal or lawyers, let's call them lawyers for short. So the question of when to appoint a legal representative, and just to come back, a legal representative, one must remember, if we then again look at other terminology that is used, the Americans would talk about a best interest lawyer, and if we have to try to convey that back to the South African context, that will be more your curators. But one must remember a curator is not a legal representative. So a curator is not purely there to represent the child, to be the voice of the child. A curator is there to investigate, to assist the court, to make recommendations. So to appoint a legal representative, again, this idea of when there'll be a substantial injustice, if you look at especially the Legal Aid versus R and the governing body of the Hoërskool Vogwel, it will see that they talk about the warring voices of the parents, when those warring voices of the parents drown out the voice of the child. In those circumstances, there will be a substantial injustice. So to give you some kind of idea of when that will be. There's also guidelines which I will share with you in terms of the Center of the Child Law that sort of try to look at certain types of cases of when this will happen. So typically one would think of where the family advocate has made recommendations, but the child come and says, no, I don't agree with those recommendations of the family advocate. That would be a very good example of when a legal representative needs to be appointed for a minor child. Or if there's clear, if it's a matter that deals around discrimination of a child, that deals with the sexual orientation maybe of a child. A few years ago, we had a case where the child was transgender, and the social workers then decided to remove the child because they were not impressed with the fact that the mother was allowing this child to live out the gender that this was a boy, but he saw himself as a girl, and the mother gave him space to live out that perception he had of himself. And the social workers then duly thought that, now this is not a good idea and the child should be removed. So again, in those circumstances, it would be a good idea to appoint a legal representative for the child so that the child can have its own voice in the proceedings. That's ultimately about him. What does he want? I think it comes to also to this. That's where a lot of the opposition comes in, because people will tell you that, but the child cannot decide for themselves. Okay, the social workers and the psychologists will tell you, no, a child is not supposed to choose. But one must not forget that child participation and listening or considering the views and the wishes of a child is not about a child choosing. It's about the child saying, this is what I want. This is my life. I recently read a book called Child Participation, and the author in the book makes a statement, and I was thinking it was one of those statements that I thought, duh, I mean, that is so logical. He says, a child knows best about the child's life. And I mean, that's so true. What that child's truth is, only he or she knows. It's not the adult. It's not for the adults or the parents to tell the child what the child's truth is. It's the child. He knows best, or she knows best what their truth is. Okay, then what type? And I also hinted at that. So what type of legal representative? So you can get direct representation, where a child gets, let's use the word a lawyer, and that lawyer represents the child. That lawyer takes instructions from the child and conveys it to the court like an adult. And again, I find that people struggle with that idea that you will take a child's instructions and then convey it to a court for some reason or another. That's not acceptable. But if you say a child participates, how else will the child participate if the child's instructions is not conveyed to the court? Again, I think this perception of the mere fact that it is said to the court, then everybody is under the impression that it's going to happen. And I think sometimes it does. I mean, sometimes the presiding officer or the judge will follow that wish, but sometimes also they won't. So it's not just the fact, for the mere fact that the child says so, that it will happen. Then I think, again, if you go back to the judgment that some of you referred to in your assignments already, the Soller versus G matter, where Judge Satchwell so clearly and nicely painted the picture of a lawyer or legal representative is someone that stands in the corner, that stands squarely, I think is the word that she used, in the corner of a child, fighting for that child. But also you will remember from that judgment, Judge Satchwell does say that that lawyer still needs to put an adult perspective on that voice of the child. So I always use the stupid example of to say that clearly if your 14-year-old client comes to you and say, no, I want to go and stay with my boyfriend. Yes, the child might be saying that that is her instructions, but naturally you're not going to go to court and say to the court, no, we must put the 14-year-old with her boyfriend. That goes against what Judge Satchwell says in her judgment of, yes, you are there squarely standing in the corner of the child, fighting for the child, but you do have to put on an adult hat and also see that instruction that you get in the bigger picture, is it almost, I want to say legal, but I mean, is it a best interest? Is it a practical instruction that this child is given to you? So the other type of legal representative is the curator ad litem, which usually you will find that the court will appoint for more your younger children, your 3-year-old, your 4-year-old, your 2-year-old, your babies, where there's really big disputes, and going back to that test of the warring parents and drowning out the voice of the child. Yes, a 2-year-old or 1-year-old cannot have a voice, but they have a right, and the parents can be, because of their own interest, be trampling on the rights of that child. So the court will then more likely appoint a curator for the child to do more of an investigation and then make a recommendation as to the best interest. What makes it easier if you act as a curator is that usually, or in most cases, the court will give you power. So the court will say, you must do this, you must do that. You have the power to do this, you have a power to do a directive. So it's easier sometimes to be a curator because you are backed up by a court order giving you certain powers and telling exactly what it is that the court wants from you. So that's a bit easier. The difficulty, what I nowadays find, is that if you're appointed as a curator, then somewhere there's a parent that will tell the child, no, you must speak to this lawyer, because this lawyer will listen to you and this lawyer will do what you want, which is totally wrong when it comes to a curator. You are there to listen to the children, yes, and to hear their wishes and to take that into consideration when making a recommendation. But as a curator, you cannot just go on the wishes and the instructions of the children. A good few years ago, Judge Ranshot in the Pretoria High Court was very unhappy with me. I was appointed as a curator, and when I did my recommendation, my recommendation was heavily based on the wishes of the children, and he took exception against it. He says that no, as a curator, I cannot place such importance on the wishes of the children. I must still look at other factors, as set out in Section 7, to determine what is in the best interest of children. I think that's also sometimes when I find that a curator is appointed for a teenager, and let's say you're 14-year-old, you're 13, 14, 15-year-olds, they're given a curator, and then that curator makes recommendations. I find it very difficult because that teenager is quite capable of giving instructions, and then you get those instructions, and then maybe for some reason or another, your recommendation as a curator will go against those wishes of the child, and then you sit with a 15-year-old that says, well, I don't really care. this is not what I want. So courts that appoint curators for teenagers, I think, in my opinion, is going about it incorrectly. It is difficult. I mean, if you look at the Solar versus G, even though the court said that, you know, there's parental alienation, there's no doubt that there's parental alienation, there's influencing. The teenagers just said, I don't want to go back to my mother. And if you make me go back to my mother, I will walk away, you know, or I will make life impossible for her. And the court went and placed the boy with the father, despite all the other findings the court made. And then there has been judgments that says, yes, a child can choose their own lawyer. There's nothing in the Children's Act, there's nothing in any case law that goes against it, that the child cannot appoint their own legal representative or even fire somebody that was appointed for them. I've had the dubious pleasure of one day a 12-year-old girl in the children's court walking up to me, tapping me on the shoulder and saying, there's the door, you can leave. And she was clearly not happy with what I was saying to the court. But again, that idea that if the child can choose their own lawyer, they can also fire the lawyer that the court gave them. It doesn't really happen that often. I think in all the times that was the first time that a child actually asked me to leave the court. But I think that is something that can also happen. So how would you represent the child? I think going back to section 10 and those criteria, you look at the age of the child, the maturity of the child, the stage of development, and then participate in an appropriate way. So the appropriate way, I think we just spoke about in terms of either direct or indirectly. Indirectly also in terms of participation will mean maybe just through the reports of experts, by using, I'm sure all of you heard something which we call the Voice of the Child toolkit. So there's a kind, if the child is old enough, have that kind of interview and then have a report based on that toolkit. So you can decide. And then there's children that's old enough that have told me they want to talk to the court. They want to talk to the magistrate, they want to talk to the judge. And then that is what we do. The child goes to court and they talk directly to the presiding officer, sometimes in the presence of the other parties, sometimes not. That's really depending on the presiding officers, and most of the times it will happen in the absence of the other parties and parents. The presiding officer will then interview the child. So the age of the child, in our Children's Act, there is no specific age. Section 10 just says take into consideration the age of the child. Now, I'm sure all of you at some stage have heard this question, yeah, but my child is now 12 years old. Can he or she decide where they want to stay? Now, the Children's Act has no age. There's lots of mention of 12 and 10 in the Act, but that has reference to medical treatment, to the use of contraceptive, to publication of information. Then there's ages mentioned in those sections when a child can do something, and then if in terms of adoption there's ages, but when in terms of child participation there's no age specifically mentioned. I think recently I read an article to say that in Germany, if I'm not mistaken, if a child is 14, then that child must participate in all proceedings. So there's a must. And now in France, in their procedural law, there is they have a rule that says that in any dispute, a divorce, a residential or contract dispute, the first step will be an interview by the presiding officer, which they will then ask the child about their participation and their right to legal representation. So even at that first step, this question of representation and child participation shall be answered. So the court, our section 10 then talks about the maturity and the stage of development. I'm sorry, somebody's microphone is not muted. If everybody can just mute. Thanks. So the maturity, if you look at, again, the Children's Act doesn't have a definition of maturity, but if you go to the dictionary, they will tell you maturity deals with sort of wisdom, it deals with consistency, it deals with the idea that you consistently, if we can bring it back to child participation, so if you interview the child on day 1 of a case and you interview the child on day 20 of a case or day 100, that instructions will stay the same. So that kind of maturity, the idea of understanding what this is about, of understanding what they are getting involved in. And a maturity here, a lot of times I would find that children of a certain age will say, no, I don't want to get involved in this dispute between my parents. I have no interest in being a party to this. I am quite happy for a court to decide where I will go and what I will do. So they maybe have a wisdom, but they don't have that maturity to say, yes, I'm here. I'm standing for myself. I'm speaking for myself. I'm part of this this process. And then there's the stage of development, which we'll have a look at now, and then the participate in appropriate way. So if we look at the stage of development, I'm sure there's a lot of you that have children. You will see that there's about 4 stages that they have sort of divided child developmental stages of a child. And the one is the baby, 0 to 24 months, and then 24 to 7 years, and then 7 to 12 years, and then 12 years and up. So you will find that, especially in your 2-year, in the 2-year phase, or children up to 2 years, and very much that age, you will find that the people will tell you that they link to what they see. So if they don't see somebody for a long time, they won't necessarily form a bond with that person. So that's why a lot of times you'll find in contact disputes or residential disputes where a child is still very young, one would want to have contact between the child and the non-residential parent more often, because the clever people will tell us they can form only a bond with what they see. But naturally, as that child grows older, that idea of even knowing who you are, even though you are not there the whole time, they develop that ability to do that. But also what they will warn us for children in the second stage is that, especially when they not maybe 7 or 6 or 5-year-olds, but when they are like 3 or 4 years old, they also those children would be the ones that would call anybody a daddy or anybody a mommy, but because that's where they are. So it doesn't mean that they call somebody mommy that they then replacing the real mother with this mommy that they're now calling. It's just their stage of development. And I think for me, it's important to understand these stages because, sometimes, and I'm sure you will have clients that will come storm into your office and say, my ex-wife's new boyfriend, my child is called him daddy. And then they're all up in arms and they want to write 10 letters about it. And sometimes just to calm them down and say, okay, whoa, let's look at the child. Where is this child? What's the age of the child? Before, just writing letters and bringing applications, just looking at the child. Because I really think sometimes when it comes to child participation, it's really important to say, okay, who is this child? Who is participating in this? Where is this child? What's the age of the child? And move the focus to the child, which should be there always. But if you're going to act for the child, it is so much more important for people to focus on the child. And I also think that sometimes the mistake that people will make is that children of this age cannot give instructions. Now, look, I agree with you, 3-year-old, 4-year-old, they, in terms of instructions, they can't tell you outright, I want to do this or do that. But I think 5, in my own experience with children that I've represented, you can find the 5-year-old, the 6-year-old, the 7-year-old, they're quite capable of telling you what they want, and not necessarily stupid things that they want, but real things that they want, that have an influence on the dispute between the parents. And they will tell you, this is what they want, that is what they want. And if you really look at it, it's good things that they want, and it will show in an understanding of that they understand what this is about. So I'm always careful, because a lot of times you will find people that will say to you, oh yeah, but child is 5. No, the child cannot give instructions. I think on, most 5-year-olds, yes. But I'm always careful for that blanket, no, they can't give instructions kind of approach. The next stage is 7 to 12-year-olds. I think this is the group that I find the best, almost, in terms of that, of giving instructions, of giving you information, because they are so honest. They're really the ones that will tell you without any hesitation exactly what's happening, who's saying what, who's not saying what, who's influencing who, because they don't have the ego that the teenagers have. So they don't have that thing of, okay, what must I say to make things go my way. Unfortunately, we found more and more children, even the 10-year-old, the 11-year-old, they get very clever. They see that the parents are not talking to each other, so they do tend to develop this ability to be a bit of pleasers. But I mean, they are dragged into those situations, and they just, they will use it. And they would, but also they struggle a lot, because they will be the ones that realizing, I must now, if I go to, I've visited my mother or my father this weekend, and I must now remember Sunday night when I get home, I must remember not to do this or not to do that. So they sometimes struggle also the most, because they try still to be honest and please everyone. And then you get to the teenagers. In terms of representing them, I think sometimes it's really the easiest, because they are clear on what they want. They are of an age, it's about me, myself, and I. So a lot of times their instructions will be about them, what they want, and what is going to make their life the easiest. But also, I think it's not always true that they would want to do that. They would necessarily go to the parent that is less strict, that allows them cell phones and tablets, and but they also the ones that can make a judgment in terms of liking and not liking. And I find more and more a lot of them will look at the parent and say, well, I don't like you and I don't want to see you. That, the fact that you shout at me, that you call me names, the mere fact that you're my mother doesn't mean I have to like you, and I don't want to see you. And the children will nowadays, a lot of these teenagers will say, well, I don't like her. She shouts at me. The most favorite thing that people, or especially mothers, will tell their teenagers to say, I carried you for 9 months. You need to love me. I struggled when I carried you. And I can guarantee you that kind of approach with a lot of the teenagers is the most incorrect approach, because what they go is like, and, and one must always remember, when I say about if it's a smaller child or the teenagers, we are not dealing here with the normal child in a normal situation, in a normal kind of family setup. We are dealing here with children if I go back to the words of the case law, that are caught up in the warring voices of their parents. So this is not the normal teenager with a teenage, mentality. This is a teenager that is caught up in this war between his or her parents. And that is why we're giving these children voices, because they need to have their own voices in amongst this warring voices of their parents. And it's just teenagers are at a stage where they really would say, you know what, I do not want to deal with this parent or that parent. And also I think a lot of them nowadays go like, why should I? Just because my DNA is the same as yours. And that is a lot of times nowadays the approach of especially the older children. So in terms of child representation, if you get there, is to always meet the child. And you will, and why do I say that? Is to get your own impressions. And I think a lot of sometimes my colleagues that act for children will say, but why do you want to go and meet a 1-year-old baby or 6-month-old baby? But I really think it's important that you, first of all, put a face to the client that you are representing, even if it's a 6-month-old or a 1-year-old baby, that you have that own impression. And a lot of times, if you meet that baby, and if it's a baby that has been removed, the place of safety parent can a lot of times tell you, yes, when this baby came here, the baby, weighed 1 kilogram, but the ideal weight at that age should have been 3. This is what they found when the child arrived. Or a few years ago, I acted for about a 3-year-old girl, and when I met her, she couldn't identify colors, she couldn't do things that a typical 3-year-old will do. And if I didn't meet her myself, I wouldn't have that knowledge to make that determination and ask why. Why is this child so far behind in terms of developmental stages? And as I said, also you can then test the child's response against the stage of development. And yeah, where it's very important that you have if you want to start representing children, that you have a good relationship or partnership with a social service professional. It's very important because you're going to have questions about stages of development. Should a child of 5 be able to do this? And if you don't have that formal training, you need somebody that you can call or that you can sit down with and say, look, this is what happened. And nowadays also what happens more and more when you have specifically difficult cases is that you consult with the child with the social worker. But there I would really advise that if you're going to involve a social service professional in a consultation, that it's somebody that I always almost want the word be comfortable with, that person understand where you come from and you understand where they come from, and that you work towards that you both have the same ideas about what is this consultation about, and that you also allow each other to approach the consultation how you want to approach, because afterwards you will then go and say, oh, okay, this is what I saw, this is what I heard, and that's why you then sometimes will go and do it in partnership. In terms of participation in an appropriate way, I think I touched on it already before, to say that you need to ask, is the child going to testify in court? Or are you going to make an affidavit for a child, or indirectly? Indirectly meaning through a report of some kind, and then also how the parents will play a role. So the affidavit, I think a lot of time people have this immediate reaction, say no, a child cannot make an affidavit. And yes, I think a child of a certain age cannot make an affidavit, but if we say on the one hand a 15-year-old or a 16-year-old is mature enough to participate, there's nothing wrong in drafting a statement for that teenager or the 15 or 16-year-old. And usually also, if you do an affidavit for a child, it will not be drafted in the same way. Naturally, you're not going to draft it in the real formal way that you will do with an adult's affidavit. You're going to use simpler terms, and you're going to, for example, where you would say that, I confirm the truth of the facts, and that's typically paragraph you put in for an affidavit. You will change that to say, I understand the difference between a lie and the truth. So you will really simplify the language of the affidavit. And if you're going to say testify, well, then you need to sit down with the child and say, okay, testify how? Are you prepared to talk in front of the other parties, or do you want to talk to the magistrate or the judge by yourself? And you'll find that I recently finished the case where two teenagers the application was brought by their grandparents to have access to them, and they were totally against it, and they didn't want it, and they said, no, we want to tell the magistrate that we don't want to see our grandparents, and we don't want to mind. We want to say it in front of their lawyer, in front of the other lawyers, in front of the other parties, because that is how strong they felt about it. But I think there one must be, if you represent a child, you must be careful if the child is really up to that, testifying in front of the other parties. And I think most of the time it will really be in the best interest of the child just to have a conversation with the magistrate by themselves, with you there as their legal representative to guide them, because they ultimately also must sort of guide their testimony, same that you would do an adult witness. So just if you then represent the child, remember you must still consult with the child. You must try to build up a relationship with the child. Why I say that is that you'll find that a lot of times children, when you represent them, you are and they will tell you, I think a while ago I consulted with a child and we worked out that I was the 13th professional of some sort that was consulting with her. And you must realize at that stage, the children are done and over it. They don't want to talk to anyone anymore. They've told their story gazillion times over. They don't want to talk. They don't want to tell it again. So it's really important that you have a relationship with that child, because the child will, they tend to then don't want to talk. They're withdrawn. And even though sometimes the child, we sometimes want a child to be different, but if we think about it as an adult, you sometimes meet people and you will go like, okay, I don't know if I like you. And you will sort of just be pleasant and have a small chat with that person. And the same with the child. Sometimes a child, because of what they've been through, they don't know if they can trust you or not. So it will take sometimes you won't in the first consultation necessarily get in all the information you want. You might need to see the child 2 times, 3 times to build up a relationship. Also, be careful of the time and of when you consult. Remember, especially the younger children, for you that are parents, the longer the day, the tired child, they've done with school, they're now done, they want to go and play. And now we want them to come and talk to another person. So just be a bit sensitive about that and how you talk with the child. Having an adult conversation with the child is not always the good idea. I like taking coloring pens, glitter pens, scissors, glue, toys. I have a whole bag full of these things that when I go with it to a child to consult, I usually take the bag with and I say, there you go, there's the bag. And then the child, while they talk to you, then sometimes a lot of them will start playing or they'll start drawing. And it's just that you're putting them at ease. And then it's also important, like with your adult clients, that you explain to the child in an appropriate way what is the options and what is this all about. And just some useful guidelines when you deal with the child to say, try to see the world through the eyes of the child. Where they at that stage, and just thinking that they are so fed up with this processes and this idea that but everything is for your best interest, it's about you. And sometimes children go like, oh no, it's not really about me, it's about my parents. Explore and understand all the aspects and factors that are influencing the child's world, and how they experiencing the world. And making sure that when you communicate the needs and the wishes of the child, that you do it in a way that you also still honor the child's dignity. And what I usually will say to the child is to say, okay, you must remember now that when I go to court or I'm going to have a meeting with your parents and their lawyers, I need to convey what we have been talking about to the court or to the lawyers. And is there something that you've told me now that you do not want me to say to the court or to your parents? And it's important that you ask them that, because sometimes they will tell you something that they say, no, please don't say that to the court or to your parents, but it might be important. So it's important that you then think, okay, how can I get this information across without breaking the trust the child has placed in you. And also that idea of being creative, finding solutions, and this is where especially the younger children, they will surprise you in terms of the solutions they get. They can think of, and they say, okay, but what about if we do this, or what about if we do that? And again, one would think that a lot of times the parents will go, man, it's the child, what does the child know? But it's the child, yes, but it's the child's life. And why is it so unthinkable that we give the child the opportunity to come up with a solution? And maybe the solution sometimes is a bit simple for the complex situation, but sometimes they really have good ideas, and see how we can incorporate that. Okay, so let's stop here for now, and let me just quickly just go to the questions and see what we have here. You say, could you please share an example and affidavit you have used? Okay, I can do that, no problem. And then Yasmin, I see you joined us. Must legal representatives appointed by legal aid submit a report when the interaction with the child, as well as the findings, are submitted to court and parties to proceedings, in particular by means of an affidavit? I've seen certain children's court in Gauteng have this submitted. Okay, so Yasmin, my attitude with this is to say that, and sometimes I can be a bit sarcastic, so apologies for that, is to say, do you file an affidavit for your client or a report for your client? No, I've never seen any one of a lawyer filing a report for an adult client. So why on earth must I file a report if I represent a child for a child? So my answer is no. You represent a child in the same way that you represent an adult. You make submissions based on your client's instructions. Why we would sometimes file a report, and that would be more in the form of almost like a memorandum or progress report, is when you're appointed as a curator. Then the judge will say to you, look, they want at a certain date, they want feedback on X, Y, or Z. Then you must file a progress report or an interim report, but then you're appointed as a curator with specific powers, with specific instructions. Therefore, you will file a report. In some of my High Court matters, where I was appointed as a legal representative for a child, the challenge comes, and and how do you, in a high court matter, get your child's version before the court? Let's say, for instance, the child is still a bit young and you think a statement might not be an appropriate way to participate. Then filing what I call a memorandum, more in the format of a heads of argument, I will then place in front of the High Court to place the version of the child before court. Or if the child is old enough, referring to the affidavit, which I will let you have, is to, if the child, and I've represented children that says that, for example, I don't want to go back to my mother, but really have a strong view on that. And then drafting an affidavit for the child and placing it before the court. But that is the testimony of the child. That is not the legal representative filing a report, because, I mean, as a legal representative, you can't file reports. I mean, you're not a social worker. So that's, that's why I really kick against it, especially in the children's court setup where there is social workers to write reports on circumstances. You are there to represent the child. I see Jasmine is typing, so I just want to see what is the question. You can also just ask Jasmine. Oh. Yeah, Yasmin, I did share also your concern with my colleague at the Tanin local office, and she did say that she will also give you a call because I heard your concerns the last time. But I think, I mean, that legal representative who doesn't interact with the child in any way will not be in a position to file a report, because for you to file a report, if you now think you need to, as a legal representative, you need to be able to put information in the report. And the only way you're going to get that is if you actually consult and interact with the child. Okay, any other questions? You can also just raise your hand and just ask a question if there's something that you want to know. I don't know if I missed a question. I see somebody is typing, Fendi. I just give it a moment for the question to come through. Fendi, I don't see Grace. I don't know if Grace is still with us. I see Grace is not with us anymore. So maybe just drop her an email. She will be more in a better place to answer that question. Okay, thanks. Yeah, I can also maybe just mention, Teresa, I see you were very upset this past week. And I did raise it with Grace also. In terms of the technical issues behind the webpage, unfortunately, I have no control over that. But I did raise it with Grace in this week to say, look, we need to find a way forward that that you guys are not so frustrated that you don't know what's happening. The one suggestion that I made that I want to make to Grace and to Lead is that maybe as we do a course, the 9-week or 11-week course, that we create a little WhatsApp group for the students for that specific block, that for the time that the course runs, there is a better communication between the facilitator and the students, so that we don't get frustration and unhappiness and I don't know what's happening and I'm in the dark. Maybe that's a different, more direct way of dealing with it. Okay. Okay, I see that's a good. Okay. Yeah, I think everybody, you know, if I look at how we deal with stuff nowadays, we all used to WhatsApp groups and dealing with information via WhatsApps. It's just a much more direct, quick way of communicating with each other than emails that in any way doesn't come directly to me. I see Effendi is just typing something. Yeah, sure. You can type me. You can email me questions. I don't mind. You can just ask me for my input. I don't mind. I think my email address, if I'll quickly put it out, have it. Yeah, I think also what Teresa has found is that sometimes if you just be careful if you email me on that address, if you have weird topic or subject lines, the web marshal might block it. But I will usually see if it is blocked. Kuleka, I'm not quite sure what to say to you. I've now posted it twice as part of the forum and as an announcement. I know the portfolio did go out as part of an email to everyone. And the email, as far as I can understand, did reach everyone. So again, Koleka, can I maybe just ask that if you keep on struggling, that you maybe just drop Grace an email, because as I said, I've posted it twice now. Okay, I see. Oh, okay. Okay, thanks. Phew. Okay. Otherwise, I was going to cry. I'm really sort of like Teresa saying, then I'm going to give up, and I don't know what to do then. But yeah, thank you for that. Okay, so let's look at the last part of, if nobody else has questions about either portfolio 2 or child participation, we can move on to the last section. Okay, so I see no questions, I see no hands. Okay, so let's go to the last bit to say the proposed amendment. So what I will also do is I will upload the proposed amendments with the PDF document, so you can see what they are proposing in terms of amendments. I think I did mention during our last or our first webinar is that the problem with these proposed amendments is that it seems almost that everybody is keep on giving suggestions and input, so they can't get to final amendments. That seems is one of the reasons why the amendments have not been finalized and have not been published. But I still want us to just look at a few of them that you can sort of maybe start thinking about how it will affect the way you run your practice, how it can affect things that you are dealing with day to day. So in terms of section 1, it's interesting that now eventually they are deleting the definition of the divorce court and reference to the divorce court in the Children's Act. For those of us that has been in practice long enough, you will remember that there was long time ago, there was the Northeastern Divorce Court, there was the Southern Divorce Court, there was the Central Divorce Court, and these courts were usually periodical courts that went from town to town. And when the Children's Act was written eventually, or first I think it was, they started with it in 2000, and I know it was only finalized. At that stage, divorce courts were still active. So when they wrote the Children's Act, they made reference to divorce courts. So eventually in this amendment, they're deleting the definition of the divorce court and we're removing it in all areas or all sections of the Act. So what they are inserting is a separated migrant child. Again, this amendment speaks to the reality of what we are dealing with in practice every day. So this amendment would bring the reality of children, what we deal with every day, so that we can also understand what we're dealing with. So the definition of a separate migrant child means a child that is not a citizen of the Republic and who has been separated from both parents or from previous legal or customary caregivers, but not necessarily from other adult family members, including a child accompanied by an adult family member. So typically, a child that is left behind by a mother that then goes back to her country of origin, but the child stays behind. And then what now? There's sometimes with children that I've represented, you'll find that the child is in South Africa, the mother is not here. The father is a lot of times, well, nobody knows who the father is, or the father might be deceased, and somewhere, in the child's life, but also not very active, is a family member. And what kind of child are we dealing with? That child is not a citizen. A lot of them don't have birth certificates. So just the definition of a separated migrant child. Again, section 8.4 that is inserted. Again, just emphasizing something that is hopefully implemented in practice. But again, I think you will find that sometimes people want to not do this, but then just saying this act applies to every child in the Republic of South Africa. So not necessarily South African children, but every child in the Republic of South Africa, which I think is very important, because you find especially government institutions that, and I think the Department of Education, for example, that comes up now, if I think about it, they want to say, no, children have rights, but, that very important but, as long as the child is South African. But no, that's not true. The Children's Act and the rights and the protection and the objects of the Act is applicable to every child of the Republic of South Africa. So I think I previously also mentioned that part of this amendment is they want to change Chapter 3 that deals with parental rights and responsibilities to have a Part 1 and a Part 1A. So the Part 1 will deal with automatic acquisitions of parental rights and responsibilities, and Part 1A will just say acquisition. So this deals, you'll see the next slide, it deals with Section 21. I think in your own practice, there would have been a lot of instances where one would ask the question, but if you look at the facts of the case in front of you, does it not seem that the father has rights? So wasn't there automatic acquisition? Does he now have to jump through 10 hoops to get the parental rights responsibility? Because it seems all the boxes are ticked. So does he not have those rights? So again, the Part 1 and Part 1A is to give effect to what is in any way in practice happening, and just to make it a bit easier. So the proposed amendment is inserting Section 21(1) big A, which then gives the family advocate the authority to issue, in a prescribed manner, a certificate that the biological father automatically acquire full parental rights and responsibilities. Again, we're placing a lot of reliance on the family advocate. The question I'm sure all of you will have is that, is this not going to further burden a lot of family advocates offices that are already struggling with the work and the investigation that they have to do? But now they're getting a further obligation or further duty maybe that they have to do, and to say that, okay, they can issue these certificates that a biological father automatically has rights. So who can bring this application? A mother and the father jointly can bring this application for the certificate, or a father after reaching an agreement after the mediation, a father after trying to mediate and a mother unreasonably refusing, and a father that's shown to the family advocate that they automatically acquired rights. So they can make this application to the family advocate. So let me just go back to the previous slide. So one must remember that Section 21, with regards those criteria, is not deleted. It's just those can now be used to say, well, you comply with or meet the requirement for, let me think quickly now, you were in a life partnership, the Section 21, let me get it in front of me, sorry, let me put on a light here. Let me see, let's take the one ground to say that if at the time of the child's birth, he's living with the mother in a permanent life partnership. So if that criteria is met, then the family advocate can issue a certificate. So what I'm just trying to say is that they're just inserting a criteria, they're not replacing Section 21. So that's something to take into consideration, especially if you think about that, this third ground to say that the father can, after trying to mediate and the mother unreasonably refusing, because a lot of times as the act stands now, that would be a dead end. But now, if the father can make an application and can prove, the family advocate can issue this certificate. So then Section 22 amendment, inserting Section 22(2)(a). This speaks again, goes to the rules, but I mean the rules will be implemented before the proposed amendments. A child who is a subject of the parental rights and responsibility agreement must be given the opportunity to express his or her views regarding the content, provided he or she is of sufficient maturity and mental capacity. So now, what for me is a bit concerning, and it's sort of another little hurdle, is this concept of a mental capacity. Because now it talks about the maturity and the mental capacity. Now, I don't know what they mean by mental capacity, because who's going to determine the mental capacity? Is it, so for me, I don't know why they now had to go and put in a little extra criteria. They have Section 10 in the Act. They're not changing Section 10 of the Act. Section 10 already says how, child participation. Why they had to go and add this little tail to this, I'm not quite so sure why. But again, this concept of must be given the opportunity to express. How they, again, will have to go back to the question of, is it going to be by way of a legal representative? Is it going to be the family advocate? But they in any way interview children. But if we look at this to say, well, one would suppose that there is an agreement entered into between parties, not necessarily maybe with the involvement of the family advocate. Would then, if the agreement is sent to the family advocate, will the family advocate then have to call in the child to say, okay, what is your views? Or will the person that mediate the agreement then make provision for it? But it speaks to, you will agree, when we looked at the proposed rules, I mean, this concept is already in the rules. So this is just would be a confirmation of the rule. I think really, in my opinion, they must some stage really be more prescriptive as to how they want it done. Like I said, when I referred to the French situation, where it's part of their procedural law, their procedural rules, to say if you want to do a divorce, if you want to bring an application, then this is how the participation will take place. One, in the interview by the presiding officer. So I think we need to, if we move forward with child participation, we'll have to get a bit more prescriptive and move away from like terms of sufficient maturity and mental capacity, which is open for just such a variety of interpretations. Then Section 30 amendment. Section 30 deals with, before I lie to you, just make double sure, deals with the co-holders of parental rights and responsibility. And more specifically, it deals with the residency of a child. Now, I think you will, in your practice, you might have dealt with relocation applications. In my opinion, this amendment tries to some way speak to that. I recently attended the Clark's Family Conference in Johannesburg, and then there was a lady from the Law Reform Commission, and they have a whole new plan that they want to introduce, where they want to make differentiation between a child relocating to outside the country, and then they also want sections in the Act that speaks to relocation within a country, within South Africa. So if you want to move from Pretoria to Durban, then they want specific processes written into the Children's Act as to how that must be dealt with. And I must say, I've seldom seen such a very I almost want to say harsh reaction to a proposed amendment. And when she tried to present this, and none of it was positive. The feeling of the delegates at the conference was that, whoa, there's already in the Children's Act this whole idea of, if you look at Section 7, the effect of the moving a child in terms of distance, what effect will that have on relationship? There's already things in the Children's Act, and to say that if you want to move out of the country, you can in any way not do it without the permission of the other co-guardian. So there's already provisions in the Act. Why do you want to now go to be so prescriptive? Isn't it not going to make it just more difficult? I mean, relocating, I know in certain jurisdictions, I think Cape Town is the one that comes to mind. Relocation is, they have lots of relocation matters, and it's complicated as it is. I mean, they involve expert, it's application upon expert. It's already such an expensive and long process. Why make it more difficult? But be that as it may, they want to insert Section 30A into the Act that speaks to just residency of a child. So parents must agree on the residence of a child. The residence must be determined in accordance with the best interest and may include residence with both parents, where the parents are living together, or residence with one parent, or the residence with one parent will not affect joint exercising of parental rights and responsibilities. And if the dispute, the matter must be referred for mediation before approaching a relevant court. Now, I just want to go back to the section that says the residence with one parent will not affect joint exercising of parental rights and responsibilities. And one would think, but sure, isn't that a bit obvious? But in a lot of my recent curator cases, when I consult with the parents, I get this idea that parents have this idea that if a child stays with them, then they are in the pound seats. And then they don't have to co-parent because they in possession of the child. And therefore, actually, most of the things that happens with this child, because they are the primary caregiver, they will decide on what will happen with the child. But if you look at the Children's Act, even without this amendment, both parents have rights with regards to the child. So just because a child stays with a parent doesn't then exclude the other parent in terms of decisions, in terms of information, in terms of making joint decisions. So this is actually just my opinion stating the obvious, but as I say, from our last few consultations with parents, it seems this might be necessary to spell it out specifically, that just because a child is staying with you, it doesn't mean that you don't have to consult the other parent. So section 45, and that is the section that deals with the matters that the Children's Court may adjudicate. Previously I did allude to this to say a Children's Court can adjudicate guardianship applications for orphaned or abandoned children, as contemplated in section 24 of the Children's Act. So giving that, and section 24 deals with the assignment of guardianship. So open a door a little bit in making guardianship orders a bit more accessible, is to say if a child is an orphaned or abandoned child, then the Children's Court can hear those applications for guardianship. Abandoned children has a specific definition. So I just want to quickly have a look, because section 1 does give us a definition of abandoned. So abandoned child means a child who has obviously been deserted by a parent, guardian, or caregiver, or has for no apparent reason had no contact with the parent, guardian, or caregiver for a period of at least 3 months. So it's not necessarily a child that, if you think about abandoned children, you think about that child being found on the corner of a street. So that's not necessarily what they're thinking about. Yes, that child also, but where there's been no contact between a child and a parent. In terms of, I think that a lot of the guardianship applications that has come across my desk is where you have a child that has been living with an aunt or a granny following the death of a mother, and they will all tell you that, yeah, there is a father somewhere, but they don't know the name, and that father is not really part of that child's life. So if you look at abandoned children and the definition, one should be able to bring that applications for guardianship in the Children's Court. And then inserting section 1JA into 45, to say a Children's Court can adjudicate matters involving an unaccompanied or separated migrant child, or a child who is an asylum seeker or refugee, as contemplated in the Refugees Act. Again, just giving the Children's Court a bit more scope to deal with various kinds of children that now, although I think the Children's Court make a plan to deal with the children, just giving them more direct power to deal with them. And then section 45 further, just to say that you can deal with guardianship, because remember, the Children's Court stays a creature of statute. So if the statute and the regulation don't expressly give them the authority, they might, there's somebody that's going to object to it. But it says specifically with regard to surrogate agreements, the High Court will still have exclusive jurisdiction. But in certain cases, then the High Court and the Children's Court can have concurrent jurisdiction. And then also in terms of setting 3B, that the High Court, the Children's Court, or the Regional Court have concurrent jurisdiction over the assignment, exercise, extension, restriction, suspension, or termination of guardianship in respect of a child. Just again, clarification on some sort of technical issues. Why I highlighted section 1110, because currently section 110 deals with reporting of abused children, and there is in section 1110 there is a list of people that need to report if they are aware of an abused or neglected child. So what you see here is that they've now inserted some, or they've included more people that has a duty to report the abuse or neglected children. So the suggestion is that it's any officer of the court or official in the employment of the Department of Home Affairs, a social service practitioner, any person working with children, or a ward counsellor who has a suspicion, must report that a suspicion to a child protection organization. If you look at 110, they've included the word suspicion now in the new proposed amendment. I think for me, if I look at the ward counsellor, they are usually in certain communities very much the person on the ground that interacts with families, and that will come across situations where they might see a child is being abused or a child is being neglected. So that placing the new section 110 would place a duty on them now also to report any suspicion. Department of what I don't know, maybe you have a few suggestions as to why an employee of the Department of Home Affairs, I don't know how they will become aware of it. I don't know if they pick maybe up a lot of applications from a certain person about children, I don't know, but this is a suggestion that they be included, and any officer of the court. In my mind, I think maybe if a clerk of the court or see something that they also have a duty to report it. So that is the suggestion. So just making the list a bit longer of those people that must report any abuse or neglect of children. Okay, so yeah, those are the few amendments that I thought that we will you will find interesting. Okay, so I see there's a few questions. Okay, I see. Will that certificate then carry the same weight as a court order? And will the parents then be able to go to Home Affairs to add the father on the child's birth certificate by presenting the certificate? Yes, I know. That's a good question. I doubt if Home Affairs except if somebody educate them, will accept that certificate, but I would think that the certificate would carry the same weight as a court order, because it's going to be, in my mind, I see it as we say, a parenting plan was registered. It's a process that the Act makes provision for, that certificate has a proof of rights. As I say, if Home Affairs is going to recognize that certificate without that court order that says that the paternity is must be recorded, just in terms of practical experience, I doubt if Home Affairs will follow that. Teresa, I see also, yeah, I think because of the custody and access, if you listen to the writers of the Children's Act, the guys from the Law Reform Commission, the whole reason why they moved away from this concept of custody was because they said custody created this impression of possession. You know, if I have custody of something, it gives you this picture of I have control, I can do with this thing that I want because I have custody of it. You know, it's like the police have somebody in custody, you have control. And that's why when they wrote the Children's Act, they moved away from this term of custody and more towards parental rights and responsibilities, with the idea that it is less possessive kind of words. It's more, it's a sharing, it's holders of. But I think in a lot of minds, there is still this thing of custody. And you'll find the other day I read a summons drafted by an attorney in which they actually still use the word custody, that custody be given to their client. So, if some lawyers still walk around with this idea of custody, never mind the lay person in the street, maybe that's where you say, they still have this idea of, if I have custody of my child, I don't have to co-parent because I'm the primary caregiver of that child. I see there's another question coming through. Sorry, I see my voice is still giving me problems. Oh, okay. Yeah, so the students, and the question I ask is, where does the students get it? If they come with this idea of custody. And as I say, this idea, if I'm the primary caregiver, I'm the one that can make decisions, which is scary, because otherwise we're never going to move. We get to a point with that concept of making joint decisions, being equal holders. We're going to struggle to get there. Okay, let me switch on my camera. Oh, sorry, now the light is, no, that's not going to work. So sorry, now the light is very bright. Okay, any other questions, comments? Okay, then thank you very much. Yasmin, if you do not come right following my email, please come back to me. Just drop me a email or an SMS or WhatsApp, so let me just follow up. Okay, I'm glad everybody enjoyed it. I will again upload the slideshow to the page, so you have it available for just quick reference. And then also the proposed amendments I will also upload for you, and then hopefully by the end of tonight you'll have the grades for your portfolio one. Okay, but then you must have a wonderful evening further. Go enjoy your dinner and your supper. And I'm sure some of you are still going to work some bit. So yeah, enjoy. Okay, guys.